Okay, we'll get started. And let's see if to give you an overview of probate court, what we do, jurisdictions and functions. Stop me anytime. A lot of people looking for their probation officer. We're not too much of that, except for drug court. We'll talk about estate planning for every family, a little bit about elder law, civil commitment process, mental illness and alcohol and drug affects all of our families. And I know tragically we had another shooting today over there in Nashville. And I'm just wondering, probably mental illness is involved in that. So trying to get people help they need. We have points to ponder and some trivia. And let's see, chat. All right, good. The chat there, I'm trying to look at that. And so here's another way to say what our topics are. We'll talk about estate planning, elder law. We've got these divisions in probate court, marriage, civil, adult guardianship, conservatorship. Guardianship is of the person. And we want to try to avoid the guardianship by the use of a healthcare power of attorney and avoid the conservatorship by the use of a durable power of attorney or a trust. And we got some problem solving courts, and we'll talk about estate administration. And this is sort of an organizational chart, little eye test for you. What you need to know if you're probating an estate, if we look over on the left side, we've got 5 estate clerks. And from my CPA days, like each has cases ending with 2 numbers. Tina has 0 and 5. Sharon 1 and 6, Nicole 2 and 7. So, and whoever you start with, they will help you from beginning to end. And so just keep that in mind. I know some have opened an estate, and again, they'll help you from beginning in. We have about, in our state division, about 3,500 open estates. We have about 2,200 that we open each year. We're looking for somebody at our customer service rep. So if you know anybody looking for a job, we got a job down here. So I always throw that plug in there. It's hard to find workers, good workers these days. So we're looking for somebody. On our commitment division, guardianship, conservatorship. Again, as I mentioned, we do involuntary commitments for alcohol and drug and mental illness. And we do about 1,800 of those a year. Guardianship, conservatorship, we're going to avoid that through our estate planning, but we get about 1,000 of those cases open. And then we have 4 problem-solving courts. We want people to get the treatment that they need. Hopefully they go voluntarily. If they don't go voluntarily, we got the civil commitment process. If they get involved in the criminal justice system, that's where we have those 4 problem-solving courts. And on Happy Sign, we got marriage license, and I'll show you our love program later here. And here's a staff contact information. I grew up with Condon's department store and believe in customer service. And so you can call directly to your person you need to get in touch with without having to go through a switchboard, or you can email them directly. You'll also see that they have 2 numbers. And one is their direct dial at the office, and then the other is their cell number. They all have cells in the event that they're working from home. Let's see. And any questions on our organizational chart? Let's see. And I'm going to mute some of you just to keep it quiet. I think I got everybody. And we're located down at the Four Corners of Law for those in Charleston. Four Corners of Law, we've got the lower left, the mayor's office. The right side is our probate court, state court. And on the top right is the federal courthouse and the highest law, which is God's law. And what great legal historian gave it that name? other than Robert Ripley. All my questions will be trick questions here today. Then and now, it used to be the state capital, and ended up moving to Columbia. Where's my DC guy? It was done by an architect by the name of James Hoban. He's sitting over here. You'll see a model of our courthouse on the table there. He modeled it after the Leinster House in Dublin, and Washington visited our city. President visited our city in 1791, liked the work he did, and he ended up doing the White House. So when you go to the White House, you see the White House. Remember, it's done by a Charleston architect by the name of James Hoban. And we're over here dedicating a monument in his behalf in his hometown of Callan. That's my son there, Joseph. Our luggage didn't make it, so we had to buy some fans. They bought some plaid fans over there. Again, we're in two different buildings. Charleston is known as the Holy City, so we didn't want an 8 or 9 story building. We want to be able to see the church steeples, particularly if you're driving in, or if you're out on the water, you look back and you see all the different church steeples. The estate division's on the 3rd floor on the left there, and I'm coming from you on the 4th floor on the right there, and that's where our commitment division is. All right, what's the highest basketball court in the land? Gamecocks are playing tonight at 7. All right, what's the highest basketball court in the land? All right, what are the rules on jokes? Who's been in a courtroom? You might raise your hand if you've been in a courtroom. We got some speeders here tonight, Jamie. They've been driving too fast. Okay. Anyway, the highest court in the land. Let's see, got somebody in the chat. Oh. Can everybody see me okay? Just want to make sure. Okay, good. It's there in the DC of all places. It's the U.S. Supreme Court. You go above the U.S. Supreme Court, there's a basketball gym. And I made 2 shots and I retired. So when you're thinking about watching that game tonight, remember it was the U.S. Supreme Court that actually has a gym above it. You can't play while they're having arguments, so they'd hear you. Jamie's on here tonight. Our mentor was Morris Rosen. He passed about 10 years ago, but he practiced law, very much a Southern gentleman, and was a good role model for both of us. All right, let's talk about estate planning. I know that's why many of you joined us tonight. We don't want your will to look like this. This is actually a will that was probated in court. We changed the names and the witnesses' names. Basically a 1 sentence. I leave everything to my beloved wife. I think he had his list over here on the right. We headed to Costco, or headed to the grocery store, and then he did his will on the left there. So you never know when God's going to call us. We want it to look a little bit better than that, though. And you have to have 2 witnesses. You have to know the objects of your affection, know who you want to leave your property to, and generally what you own. Anyway, let's talk about 11 potential documents for you. Jamie would have sent these to you. If we were in person, I would have you pull out each one. The first is a checklist or a questionnaire. It's very important that you list all of your assets out. We want to learn a few concepts tonight. And one concept is the concept of probate and non-probate property. Probate property is controlled by the will, and non-probate property is controlled by a third-party contract. Probate property is also controlled by the intestacy statute if you die without a will. Typical non-probate property is life insurance where you designate a beneficiary. It could be a joint account with right of survivorship, like a bank account. So there's a number of non-probate assets. Those will not be controlled by the will. So very important that you pull out your source documents. Many times we think property is owned a certain way, and then we look at it and find out it's owned a different way. A good example is real estate. For the longest time, real estate in South Carolina was owned tenants in common, meaning that wife and husband each owned 50%. Now most real estate is joint with right of survivorship, which passes outside of a probate. So we want to do a checklist questionnaire. The attorney's duty is to carry out your wishes. Whatever you decide is the right answer. And they will do that. I would recommend definitely most of these documents. Some of them overlap, but we always want to have a will, a last will and testament with a trust, or we want to have number 6 there, a revocable living trust with a pour over will. And let me try to explain that. You want to have a trust. It's a vehicle or a way of holding property until somebody is the right age. So for a minor, if they were 10 years old, if they didn't have a trust, they would go into a conservatorship. And once the child reached the age of 18 in the conservatorship, we would be required to give them the money. Many times you want to hold that in trust and give them 1/3, say at 25, 1/3 at 30, and 1/3 at 35. Hopefully they learn along the way with the right to invade for, say, educational needs or medical needs. We had one trust where the child couldn't get the money till age 65. I thought that was a little bit late, but I think the parents were wanting to make sure Social Security was there at least. So you always want to have a trust, or if you've got an incapacitated adult. And if you got an incapacitated adult and they're receiving some type of government assistance, you may want to set up what's called a special needs trust so that they still get their government assistance and the assets that they receive does not disqualify them from that assistance. So we want a will. In a will, we name a person in charge of that. It's called the personal representative. It used to be called executor, executrix, now called a personal representative. And anytime you do estate planning, the attorney will ask you about alternatives. If so-and-so is the personal representative, if they predecease you, who do you want as the alternate? That type of thing. Same with when you're devising property, they'll say, who do you want to go to first? And then if that person's predeceases you, who do you want second, and on. I also want to make sure you have what's called a residuary clause, and that's a catch-all clause that allows, if you have it named a particular piece of property who it's going to, then it catches all of them. When you do number 6, the revocable living trust, what we call a pour over will really is just a 2 or 3 page will, which basically says everything I haven't already put in the trust, I now do so. And so it catches it at the end. Either way is effective. Most South Carolinians are fine with a trust inside a will. It's because our probate process is not that expensive, and probate fees compared to states like New York are a fraction. Our probate fee, as we'll see later, it's $95 on the first $100,000 of just probate assets. It doesn't, there's no fee on non-probate assets. The third document I want to talk about, well, let me back up to the will and testament, the last will. You can also reference a written memorandum, and you'll see that, I think it's in provision 3 or 4 in the will that we sent to you. And in there, you'll see that it says, I may leave a written memorandum of how I want my personal property to be divided up. And so it's allows you to say who you get your jewelry, your golf clubs, your personal property. It does not include cash or real estate. But that way, if you change your mind, you don't have to go back and pay the attorney again. You can simply just change your document. So definitely want to have a will with a trust, or a revocable living trust with a pour over will. In managing our property during the lifetime, let's look at number 3 there, which is a financial or business durable power of attorney. This allows me to name my wife, Michelle, as my agent. If I'm incapacitated, or if I'm having surgery on one of my 15 or so kidney stones, she can pay the bills while I'm out and handle the business of our household. It's not necessarily end of life, but it's just the way to pay the bills. If I become incapacitated, then by having a business or financial power of attorney, we avoid the need to come to court and get a conservator appointed. To get a conservator appointed, usually you have to have an attorney bring the action for the family. We have to appoint an attorney for the alleged incapacitated person. We have to appoint a guardian ad litem. You can see right there, we're building up a lot of costs. So it's much easier if you can do your estate planning and go ahead and do a durable power of attorney. And that's for paying bills. For making healthcare decisions, we've got, Jamie would have sent you the healthcare power of attorney. And it's a statutory document right out of our code of laws. And if you can take a look at it, you'll see that it's the same for everyone in South Carolina. That allows for our EMS, our hospital workers, to see the same document each time. It's not like reading a unique will or really having to study the will or the financial power of attorney. Again, it's a statutory document, but it does have great flexibility. You can go from maximum care to withdrawal care. You can put it in your own words. Again, the healthcare power of attorney is signed. There's 2 witnesses and a notary. I meant to back up and tell you on the business power of attorney, to be effective, it has to be recorded at a Register of Deeds office. And when it's recorded at the Register of Deeds office, that's when it becomes effective. And see if I have a question. A question is, if a power of attorney is executed in another state, would it be recognized here? Generally, it would be, but it's always advisable to have a will or a power of attorney, any of your estate planning documents, if you've taken up residence in a different state, to have that state. If you move to South Carolina, I'd have a South Carolina attorney look at your documents, but generally it would be accepted. The healthcare power of attorney, again, allows you to appoint an agent to make decisions for you. You can have maximum care, withdrawal care. You can also indicate on organ donation and cremation, those types of things. The declaration of desire for natural death, number 5 there, also known as a living will. It gets confused with the living trust. The living trust deals with property. The living will is dealing with end of life. We've seen the cases, Terry Schiavo, Nancy Cruzan, Karen N. Quinlan was an early one. It's amazing how well what medicine can do to keep us alive. We've all got to make that decision. Do we want to be kept alive? In what condition? This takes the decision making off of your family. You can indicate exactly what stage or how you want to be handled end of life. The other document I would refer to also is number 7 there, which is the 5 wishes. If you Google 5 wishes, you can take a look at that document. It's a national movement. What are the 2 certainties in life? 2 certainties in life. That's what? Taxes, which we complain about, and death, which we don't talk about. And that was the goal of this Aging with Dignity out of Tallahassee, Florida. And they created what's called the 5 wishes document. And it's a way that you can indicate to your family how you want to be treated near your end of life. If you go to the 5 wishes, if you Google it, you can download a form for $5. It's a nonprofit, and their goal is just to get Americans talking about death and dying, and then filling out and completing documents related to that. Along those same lines, we've got the DNR, which is a do not resuscitate order. It's executed by 2 doctors. I lost a brother to cancer about 3 years ago. He had a DNR. He knew the cancer was going to take him. If he had a heart attack, he wanted to go ahead and pass rather than waiting a week, another week of suffering. So it's all tough decisions we have to make. They have moved from the doctor's office to the lawyer's office. Along those same lines, we've got physician's order for life-sustaining treatment called a MOLST. Some states call it a MOLST, and that's number 9 there. This is being piloted over at Roper St. Francis with the cancer patients. And it's similar to the living will and to the 5 wishes document. Some of these documents overlap, particularly these advanced directives, and you want to make sure that when you do execute them, that you are consistent on each of the documents. Organ donation, I'll show you a slide on that. That's choices we can make. We can do that in our healthcare power of attorney. We also have Donate Life here that was created by Dr. McManus. And then the safe cremation law. More and more people are choosing cremation, and for the expense, it's very important that if you want cremation, that you go ahead and designate it with your funeral home director, or put it in your 5 wishes document or in your will. James Jordan, Michael Jordan's dad, was killed in North Carolina, body dumped in a rural county in South Carolina. They took a dental mold, cremated his body because the small county didn't have space to keep him, and then realized weeks later it was James Jordan. And so our state passed what's called the safe cremation law. And if you want cremation, again, do that pre-need authorization, that contract with the funeral home director, put it in your will, put it in your estate planning documents, or all of your family needs to agree after you pass. This is my mom, and it's always important to have somebody advocating for you. About a year before this, the doctor at the hospitalist said we need to let her pass. She was having terrible back pain, screaming, couldn't get comfortable. Her mind was sharp, and we brought in a doctor from the outside, gave an epidural, and she lived another year. So very important that even though we do these 5 wishes and all these documents, that you have somebody advocating for you or a family member. All right, I wanna tell me if y'all like this joke or not. We can. Man got run over by a steamroller. I don't know if it's gonna. Y'all tell me if I need to drop that one. Okay. Trying to at least make you smile or laugh. I know probating a state, doing this is particularly when you lose a loved one. The first estate I probated one was my dad's when I was in law school with the help of an attorney. Recently did my brother's, and did my mom here recently. So it's I know it's not hard. We're here to help you and try to make the best of a bad situation. If you want to help others and don't want to bear the administrative costs, universities, churches can help you there. And we're also blessed in our community with the Coastal Community Foundation. And most cities, towns have community foundations. They take away the administrative cost and allow you to have self-directed charitable organization. We have a great deal, or did have a great deal of heirs property. And we're blessed with the Center for Heirs Property. They just moved from West Ashley up to North Charleston off of Rivers Avenue in the Opportunity Zone. They help families get clear title by either probating an estate, the estates, or taking a quiet title action over in common pleas and then over to the master in equity. I think mostly they probate the estates, but they have lawyers on staff. If you have heirs property, they will assist you. They also do wills clinics. And remember, Reverend Clemente Pinckney was instrumental in passing that right of first refusal. So before an heir sells to a developer, the other heirs will have a right to buy. If you're looking for an attorney, I would strongly recommend looking at this free service, which is called Martindale Hubbell, martindale.com. You can see there. It lists all the attorneys in the nation, and you can look at them by location. You can look at their academic credentials, and then you can also look at their peer rating, A being the highest. One of the better ways to select an attorney or professional is through Martindale, more so than a TV ad or newspaper ad. Again, I'd look at Martindale, and again, talk to friends and family when selecting an attorney. And remember, the kids can pay for your estate planning, and the attorney's duty is still to you. So you got Mother's Day and Father's Day or birthday coming up. The kids can pay for the estate planning. And the duty is still to the person they're doing the estate planning for. If you cannot afford an attorney, we have a number of services. First is Charleston Pro Bono Legal Services. Another is South Carolina Legal Services. If you don't qualify for either of those two, we also have Charleston Legal Access, which is sort of in the middle there.
Can you go back and show those other two slides, the pro bono and the
Sure,
other one?
sure. Charleston Pro
Thank you.
Bono, you're welcome. And you'll see the income limits down on the bottom right. And you see their website there. Jamie, I'm trying to
Okay.
think, we probably need to throw a phone number on that one. And then South Carolina Legal Services,
Thank you.
sure. And Charleston Legal Access, they will do it on a sliding scale. So all
Okay.
three very good organizations.
Thank you.
You're welcome. And then we've got organ donation. I mentioned that earlier. Dr. McManus was the recipient and donor. He has since passed, but he and Jamie Lassad, the late Dr. Lawrence McManus, and probably the late Morris Rosen on both those slides.
Yes, sir.
For those that have passed, thank you. And they got Donate Life South Carolina. They have a number of good forms that can help you. And I've not been to Italy, but the California family was there. They lost their son. They gave up his body for organ donation. The Italians didn't really have a program in place, and he changed the culture there. Elder law, I'll just touch on it briefly to give you one site that I really want you to consider. Hopefully we all have long-term care insurance. Of course, it can be expensive unless you buy it while you're young, like anything. And that would be the Palmetto Project. They will give you free advice concerning health insurance and options and Medicaid, Medicare. They actually, if you call them, you can make an appointment. They actually will come out to your home and give you free advice.
Yeah, that's who I work for, Palmetto Project.
Oh, do you? Who's that?
May Lucas.
Hey, good. I saw your Jamie and I came out when you had the open house.
Yes, and I wasn't there that morning.
You weren't there. You
I
were
was-
playing golf, huh?
I was under the weather. I wish I
Okay,
was.
sorry, I'm teasing you.
Yeah,
You got a nice, y'all do good, great work out there. Thank you for the work
Thank
you do.
thank you.
You want to add anything else about what else y'all do at the Palmetto Project?
Yes, mainly it's the Obama healthcare, it's Medicare, Medicaid, especially with families who having special need kids as well. We do the TEFRA program. Every agent that's there is excellent. They go far and beyond. Just like you just said, if they're unable to come to the office or speak over the phone, those agents will go to their home or visit them in a good location as well.
Okay.
Mhm.
And you're located right there on Rivers Avenue.
Yes, 6296 Rivers Avenue. Same building as Trident United Way. We're on the first floor.
Okay, good. So if anybody's interested, or they'll come to your home.
Mhm.
And we also have the South Carolina Department on Aging. It's now a cabinet level position. It used to be under the Lieutenant Governor's Office on Aging, but now it's a cabinet level. And Jamie, we probably need to add the director's picture on there. I think we got one with her. But they have a lot of wonderful services too. And then the federally funded but local program is the Trident Area Agency on Aging. The AAAs are around the country. So if you're coming us from outside South Carolina, you'll have a AAA. Other than the CAR group, there's another one in the elder law area called AAA, which is this Area Agency on Aging. And they have a wealth of information and they're located there in North Charleston. If you cannot afford a trustee, many trustees, banks, they don't want the trust unless it's $1 million or $2 million. Family Services, a nonprofit doing business as Origin, will serve as the fiduciary, and very helpful. So in the chat. Question was, any of those organizations handle Social Security disability? Let me ask Ms. Lucas. I don't know if y'all do any work in that area.
We have the resources. They will give the information, and they will assist you in that area. as much as they can. But they are connected.
Okay. I would
Yes.
say try each of these, even try an area agency on aging and family services. But you may end up having to get your own attorney when you're coming to for disability. And there are attorneys that specialize just in that. And then everybody should take a ski vacation. Any skiers here? Let me look. No skiers. I gotta be skiers here. That's spend the kids' inheritance. That's what the ski stands for. Okay. Never know when God's gonna call us. And so think about that. And if you don't want to spend it, you can actually leave it to your pet. South Carolina now would recognize pet trusts with the revisions to the trust code about 3 or 4 years ago. We had 2 dogs here in Charleston County, got $900,000 in trust. Could not be kept outside on a chain. Any surgery was down to Auburn University. And then another dog out on Kiowak got a home. So I don't know if they love their pet that much or the kids weren't nice to them. So any seniors here, if the kids aren't being nice to them, just tell them you're going to leave it to your dog or your cat and tell them to come around. Let's talk about wills, probate, and estate administration. Those that are probating an estate. We have a version of what's called the Uniform Probate Code. The policy there is to give notice to individuals that have an interest in the estate. And then if no one objects, then it goes through administratively. And we have 3 ways to do it. First is a summary proceeding. If the estate is less than $25,000 and no real estate, you can open and close the estate 30 days after a person is passed. We have normal administration, which takes 8 or 9 months, 9 or 10 months, because our creditors period is 8 months. Some states have a creditors period of 4 months, some a year. We're kind of in the middle at 8 months. So you give notice to what we call interested persons. And we'll take a look at that when we look at a particular file. Interested persons would be those people named in a will called devisees, those people that would take, if there's not a will, called heirs, and potential creditors, which we give notice through publishing in the newspaper. Most of our cases are normal administration. Our contested cases are fewer, but the court's involved and there's notice and hearing generally each step that we take. And the will contest has kind of gone away, not only locally, but nationwide. People aren't waiting until mom or dad passed to get the money. Usually the battles are in the powers of attorney, the joint account with right of survivorship, or the conservatorships. Yeah. Okay.
May I ask a question?
Sure.
If someone has a trust and let's say they didn't put the vehicles in the trust and the vehicles, one's Mercedes, the other one's Toyota Tundra, very easily, depending on how old or new they are, they could exceed that $25,000. But if they don't exceed that $25,000, everything that's in the trust is going to be fine, but they would still have to go to probate for those vehicles. Am I correct in that?
Yeah, you're correct in that. And that's kind of what I was alluding to earlier. When we have a revocable living trust, we also want to have what's called that 4-over will, because many times people will do their estate planning. They'll put everything in the trust. Then they leave the attorney's office and they buy a car, buy a boat, and they put it in their individual name. And so then they're having to go through probate for those individual assets. Sometimes you can have very substantial size estates inside of a trust, and they still have to go through probate, but it would just be the probate asset, which may just be a car or a boat. And hopefully it's under 25,000, and they can use that summary proceeding. If it's not, then they would do that normal administration. So that's why if you do the revocable living trust, make sure you put all your assets in that trust. And that's probably another reason to consider just doing a will with a trust. It makes it simpler. Yeah.
Thank you.
Sure, hopefully that helps. And for those that are doing the probate administration, used to have to come down in person. We now have electronic filing, this easy filing. And we're the first and only in probate court in South Carolina with it. We're open 24/7. You file something and our clerk will take a look at it and generally accept it. And then we also have, if you're needing a marriage license, we've got Love, which is live online virtual e-marriage application. We're trying to get in every country. The only country we're not in is North Korea. Jamie's working with Dennis Rodman to see if we can get in there. I don't know. I'll be like my bad jokes. Okay. Anyway, it is a $7 fee and it's payable to our Atlanta-based company. It's only a one-time convenience fee. You pay that, and then you can file as many documents as you like, as often as you like. So you can. I think it saves you the trouble of driving down, paying to park or to mail. You'll find the electronic easy filing much easier. I would mention that if you have a will, so you want to make sure you deliver that to the court or use a courier. I would not trust the U.S. Postal Service with an original will. And if you don't have the equipment at home, actually any smartphone you can file electronically. But if you don't have a scanner or everything else at your house, you can go to one of our libraries. And we have set up where you can do electronic filing from them. Here I am up at North Charleston at Otranto at their library, showing you that I can even do it. Scan it in and file a document. Again, it's at no charge. Just once you pay that one-time $7 fee. What are we seeing at the court? Again, we have a number of trusts and estates. Let's see another question. Somebody wants to be able to assist with amending a death certificate, or would you advise to seek legal counsel via the? Yeah, I would seek legal counsel there. We do get involved in death certificates, and we'll look at if somebody is missing or if they died from an accident. The probate court would issue an order, and then from that order, DHEC, Department of Health and Environmental Control, would issue the death certificate. That's generally when we get involved. I would have you seek legal counsel, and then you could talk free of charge to the coroner and ask her how they would change a death certificate. Okay. Somebody asked from our New York friends, do you have to appear in court? Generally, there's no court required unless somebody challenges or demands a hearing at the end of the probate process. And we'll look at that here shortly. We'll go through the process of giving notice to heirs and devotees. And then when we close the estate, we send out all of the closing documents and a notice of right to demand a hearing. If somebody demands a hearing, then you may have to appear in person. We also are doing virtual hearings, so you may not have to come down. We do virtual hearings using Zoom, like we are tonight. We lost the Charleston Nine tragically. I grew up with Billy and Randy Hutchinson over the west of the Ashley on the playground. We found that many of them considered it bad luck to get a will. And so we want to make sure that all our first responders have a will. They're the ones running into the burning buildings we're running out, and we want to make sure they do have a will. Emmanuel and I were murdered a couple blocks from where I am sitting now. They showed that love conquered hate. We didn't have any violence here. Reverend Clemente Pinckney, there in the middle, he was instrumental in getting the right of first refusal for heirs. All of these are beautiful people and beautiful families. And I was honored to be able to do a probate workshop for their families about 10 days after that tragedy at the local library. On the top right is Cynthia Graham Hurd. And I think about her every time we go over to the West Ashley branch. It's named after her. She was a librarian. Football season, Clay Matthews there on the top right, with the boxing coach here locally at the Citadel. They had reformed their trust, and my son's always collecting autographs. And I jokingly tell him that they needed my autograph to change that trust, but he got all their autographs because it's a public document and you can see what they signed. We got the Masters next week. You ready for that? This Charlestonian actually won the Masters straight over there in James Island's named after him. The lesson here is he had a son come watch him in a golf tournament. The son on the way home got tragically killed in a car accident. Dad couldn't deal with it. Didn't tell his attorney about his predeceased son. And so later we had to do a court hearing so that the children, the grandchildren, children of that predeceased son also got a share. Shoeless Joe Jackson allegedly threw a World Series. There's a statue of him in Greenville, South Carolina. And then over at the baseball park, there's a hill named after him. He didn't sign many documents. One document he did sign was his will. And they sued the probate judge to get the original, which goes to a baseball collector. It was worth about $75,000. The Supreme Court said, no, if you're famous, you file your will with the court, it stays with the court. So just keep that in mind. Spoleto starts here in May. The countess that started it or funded a great deal of it and still benefiting our community. She used a local attorney to help. And you can name your trust anything. James Brown named it the I Feel Good Trust over there in Aiken, still in a little bit of litigation. Marriage license, our happy part, I'll just touch on those. We've got the LOVE program, which is live, online, virtually marriage application. You can be anywhere in the world except North Korea, and you can apply and get your license. It's good only in South Carolina, though. And Jamie threw this one, and so it begins. I don't like the tone of your I do. I don't know. Just trying to get some smiles tonight. Who's coming through to get marriage licenses? Everybody's coming to Charleston. Dr. Cooper, you see him on TV. They have gotten, I think they might have visited family court too. Met Blake Lively and Ryan Reynolds. I didn't know who they were when they first came in, but I got to know them. And figure skater, locally, foodies. And then this couple got married. I always like to show them because it's right here in our office, the marriage license division. And look at the name of our division over there on the right. It's called the commitment division. So you got to be committed to get married. Civil commitments, I'll just touch briefly on what's affecting all of our, I worry about the shooter today. I'm sure there's probably mental illness involved there. But mental illness, alcohol and drugs, again, affects all of our families. We hope they'll go voluntarily. If they won't go voluntarily, then we have a civil commitment process, which is an involuntary process. And we hold hearings at different hospitals. We've had some high profile cases come through. Hearings generally are closed to the public. With Miss Boland, we almost had a Sandy Hook issue there. Unfortunately, gun jam, but we're trying to get people the help they need. And now after Miss Boland, if you do go through a civil commitment, you lose the right to own a firearm. We have two different agencies, one for mental health and one for alcohol and drug. And under mental health, we have a number of agencies that can help in psychiatry, Palmetto, and in Charleston, Dorchester. The state DOTIS is called the Department of Alcohol and Other Drug Services, Abuse Services. And we've got a new center just opened up named after Chairman Teddy Pryor, and it's up on Rivers Avenue, beautiful new facility. We also have a lot of veterans. Any veterans here tonight? We thank you for your service. And we're honored that our VA is named after a local Charlestonian. Ralph Johnson gave up his life over in Vietnam, jumping on a grenade in a foxhole. It's very uncommon for a facility that big to be named after Charleston Private. And we've got a big issue with fentanyl. And now even fentanyl, there's one even worse than that, which is this xylazine, which is just so dangerous. Anyway, if you haven't had a chance, take some Narcan training and get Narcan, and it's available. Jamie, I guess we need to add where it's available. I think it's at any place now, isn't it?
Yes, sir. Any health department in the
Any
state.
health department in the state now has
Yes.
Narcan. Okay, we'll add that to our slide here. Okay. And you can take a little training. It's like using nasal spray, and you can't harm the person when you administer that. And it's just a one-shot dosage in each nostril. And you just empty the entire thing. You don't try it before you do it. You just make sure you empty it all at one time in each of the nostrils. Again, the involuntary commitment process, trying to get the help they need. We are blessed in this community with mobile crisis. They'll go out on the scene and help our citizens who need help. If a person's a danger to others and themselves, they may be taken into custody under different papers. And then under those papers, they'll be appointed an attorney guardian ad litem. The attorney will look after their legal rights, and the guardian ad litem will look after their best interest. We'll have 2 designated examiners. We'll have a court hearing, and we try to get them the best treatment in the least restrictive setting. If they don't go voluntarily, or if you do an involuntary process, or if they get tried up in the criminal justice system, we have 4 problem-solving courts to give them a second chance. One is drug court. I went down to Miami. The late Judge Goldstein came up and helped us start our drug court here. I went out to Seattle for our mental health court. They had an off-duty fireman get killed by a civil commitment patients, and they used the tools of drug court to start a mental health court. And Judge Russell, who like me is not a veteran, started a veterans treatment court in Buffalo, New York. And we've taken that model and started one here. We do have a veteran, Judge Cooten, a Marine veteran that heads that up. And they go through a series, it's about 15-month, 16-month program. When you get to the end, there'll be a commencement. We generally have a commencement speaker. At this one, we had Chief Mullen. And one of the requirements that you have to do is pay back restitution. Can you guess what house Brian broke into? Which house in the city of Charleston generally would you not break into?
Yours?
They'd be fine with mine. I don't have a gun. Chief Mullen was the house they broke into. Can you imagine they broke into the chief's house? And fortunately, he wasn't home, but they had Brian had to pay back the chief restitution for whatever the things that he stole. If you look on the far left picture, on the left, you'll see Judge Bruce Hendricks, who ended up starting a federal drug court modeled after our state drug court. Proud that we've been recognized on a couple of our projects, once by the American Bar Association, as we're one of the 2 courts doing an assistance and monitoring program. We were selected along with Phoenix, and I go over to the law school and train law students to do wellness checks on our seniors that are under guardianship. And then the National Center for State Courts selected our court along with Detroit to pilot this rapid response conservatorship project. The other thing that I want to just throw this slide in is smart911.com. Please jot this down and take the time to go to it. If you're in Charleston County, it is a free service, and it may save your life or the life of one of your loved ones. It allows you to put in background information, particularly medical information about you and your family members and your important contacts, so that the 911 operator can tell the EMS, whoever's coming to your house, any special circumstances that you might need. Again, we do free workshops, and this is our website. Jamie Robinson, who's been with me. All right, Jamie, how long we've been together now?
Yes, sir. 30 years.
30 years. Can we believe it? I got to figure out what do you have to give on the 30th anniversary? One of these
I believe
ladies ought to know.
$1 million, I think.
$1 million? No, is it gold, silver, or what is it? The 30th anniversary.
Look it up.
You have to look it up. I don't know what I'll get you a gift. Anyway, we do free workshops. We do them in evenings, at night, and we go to the libraries. If you have a civic association, we'll come speak to you. I'll tell the same bad jokes, and you just have to get along with those. Okay. Anyway, here's some of my ski trips before we get into state administration. St. Andrews basketball, and my son over at Fenway Park. I know that I'm spending all this money. 2 years ago, we went out to Oregon, and my wife there in Seattle is in Gum Alley of all places, and we went to the Olympic trials, had a wonderful time. I've been out there. Last year, we went over to Ireland and Scotland and England. Saw a little bit of everything. And next year, I may be going, Jamie, I think I'm gonna go to Panama. My dad was in the Army, World War II, and he was stationed in Panama. So I've always wanted to see anybody been to Panama and seen the canal? I want to see the canal, and that's what he protected. Let's see.
Oh, Natalie tells us the 30
30th
years
is
Pearl. Pearls. Thank you,
pearls,
ma'am.
pearls. You get pearls. Okay. I'll have to find some pearls. Okay. Let's talk about, again, estate administration. Any questions on estate planning? Any questions at all? Any suggestions for jokes next time? All right, let's talk about estate administration. We generally talked about the summary proceeding. In all of these, we'll fill out what's called an application. We'll also need to provide proof of death, which is a death certificate. Again, if you don't have a body, they can't do a death certificate. We have to have a hearing. And so that would require, say there's an accident. We had 2 boys drown on Folly Beach. They found a body of one, not the other. We had a hearing and then issued an order for that the second boy that they didn't find the body of. We had a sailor that hit the jetties out there. We had a small plane crash off the coast. And so we have an accident. We have that person declared deceased on that day. If you go missing for a period of time, we had somebody hop on a plane here, go to Atlantic City, never heard from. In South Carolina now, if you're missing for a period of 5 years, you can be declared deceased. So we'll start with an application, death certificate. What we want to focus on tonight probably is just normal administration. And we have what's called a sort of an index. And we would build this file from bottom up. We'd start with death certificate, and we're going to go all the way down to our closing documents. Again, the hallmark of the Uniform Probate Code, which we have, is giving notice to interested persons. If no one objects, then it goes through administratively. No court hearing needed. Again, as I indicated, we start with a death certificate. If you have a cause of death that you don't want disclosed, such as suicide or AIDS, we'll take the top part of the death certificate. Again, if you die with a will, it's called dying testate. Without a will, it's called intestacy. Again, in the documents we send to you, don't use, please consult your attorney. And this is the first document you would complete. It's called an application. We have a lot of probate forms, and they all have flexibility. So if it's an informal process, it's an application, that's the left side. If we're looking for a formal process, that would be on the right side there, about a quarter of the way down, which is a petition. So we have background information on individuals, and we're going to complete this application. We get information off the death certificate. We learned about probate and non-probate property. The second thing we want to learn is under 4A and 4B, devisees. Devisees are people that are named in the will who would take under the will. Heirs are people that would take if there was no will, or who would take in lieu of the will. Okay. In my example here, I've got dad passing, survived by mom and 4 kids. 2 of the kids are named in the will, so they'd be devisees under 4A. 2 are not named in the will. They're disinherited, and so they'd be under 4B. And we'll look later, we have to give them notice of what's called an information to heirs and devisees. All right, let's run through this. And you'll have questions concerning the will. Let's see. Question is, are the filing fees of 95 for the first 100 applicable to non-probate property? There is no fee on any non-probate property. Okay. So, and Natalie, I'm not sure what your question. What are blood? Not sure I follow it.
It's I've heard the terminology, and it's blood
Oh, you mean
stipend. Or,
Sturpees? Yeah. Okay.
yeah, what is it called?
Per Sturpees. And that's basically by going down a tree. Okay. And so generally, if someone passes and they have 2 children surviving them, and another child is predeceased, the predeceased child, if they have issue, would also take share. But the division would occur at that where you have the first living child, if you follow me. And we can look at that and more. Anyway, we've got if a will exists on page 12, you would fill out that. If you have what we call an amendment to a will called a codicil, without redoing the entire will, you can just do an amendment to the will. And then you'll sign a verification. Where's my DC? Is it Dale Francisco? Keep in mind, when you sign the verification, you're verifying the information. And the last part of that sentence says you hereby submit also to the jurisdiction of the court. So if you're out of state, you're submitting to the jurisdiction of the court here. And the judge will come along at the end. If we have a will, be informal probate, and then also informal appointment. You would actually, if our parents and grandparents actually may have been come down to the probate court and being sworn in as the personal representative. Back then it was executor, executrix. It's now done all informally. Okay. All right, everybody raise their right hand. Let's see if I can swear all y'all in. Let me see. Don't wreck, Natalie. Okay, I gotta see the bottom of your right hand. Yeah, we got an honest group here today. When somebody takes the oath, we raise our right hand, and what you look for is to see if there's a mark in the palm of that right hand. In the olden days, if you're dishonest, they take a red hot poker and singe a mark in the palm of your right hand. So that's why when you see people take a stand, that's what they're looking for. I did have one guy raise his hand and he had a mark in his hand, and it had a construction accident was the story. Okay. All right, you're parked now. That's good. We did virtual court for the longest time, and I'd have drug court and people driving. I said, you got to pull over and park. I don't want somebody wrecking while I'm in court here. Good. Anyway, you complete the application, you verify the information, you state you want to accept the job as PR. You don't have to accept it, but if you do, then you have a duty to serve with diligence. Okay? You'll give us 2 checks, one to open the estate, could be $25, $30, and then one for the publication. And you would select the newspaper, and we'll look at a newspaper publication here shortly. But it's a newspaper of general circulation in the county, and you have to publish it, and we handle the publication for you. You pay the fee, and you can choose any of those newspapers, and it runs once a week for 3 consecutive weeks. And the creditor's period is 8 months from the first publication or 1 year from the date of death, whichever is shorter. Okay. Bond is generally not required if you have a will. What is bond? Bond is an insurance policy that you'll do your job as personal representative, and it's calculated just on the personal property. What can walk away does not include the real estate unless the real estate is sold. And it's 1.5 times the value of the personal property, as you see there. Most people will waive bond, and you can do that by a form such as this. And make sure. And you can also renounce your right to serve and nominate someone else. These are all personal choices that you have to make. Just keep in mind that the probate code has great flexibility depending on your family situation. You'll be given a certificate of appointment. This is what you can take to the bank and to the financial institutions and to others to show them that you're in charge of the estate, sort of like a corporation has a president, a partnership has a general partner, and a state has a personal representative. And you also be given fiduciary letters, and they may want some with a raised seal. Okay. Information to heirs and devotees. This is what I talked about earlier. We did the newspaper publication. We also have to send out this information to heirs and devotees. People are now spread across the state, the country, the world. They may not know that a loved one has passed, and so they have to be given notice, and you'll give them notice, and then you'll let the court know. Here, mom is giving notice to the court that she has given the 4 kids the information to heirs and devotees. And you can do it by personal delivery, you can mail it. So a number of different ways you can do it. This proof of delivery is basically an affidavit. Okay. There you go. Where are we? Okay. Oh, why did I lose you? Yeah, there you are.
Yes. Would you recommend having 1 or 2 personal representatives on your will?
That's a good question. Do you have 1, 2, or 3? It depends on your family situation. Many times, a parent doesn't want to leave anybody out. If you've got 2 kids, you might name them both. You need to make sure that your will addresses how you're going to have a tiebreaker. So maybe to sell real estate, everybody has to agree. To collect property, then anyone can do that. But there's pros and cons. You generally don't want to leave someone out. It's probably better to have an odd number so that if there is a vote on something, the majority can rule. Hopefully that helps. You always want to make sure you have alternates in case someone can't serve or predeceases you. Yeah. Does that help, May? Yeah.
Yes, that helps. Because of the large family, this will does have 2 personal representatives, but it's 9 beneficiaries in the will.
Okay. Sounds like my family. I'm one of 10. Yeah.
Yeah. Thank you.
Yeah. There's pros and cons. Yeah. I'm doing it. Question is, what necessitates the hiring of a lawyer for probate? Is it the size of the estate, complexity? I'd say yes to all those. Many of our estates are done by lay people, and we have assistants helping them there. There are some times that many times the lawyer can help you and take that burden off you, particularly the emotional burden. They can be very helpful in that regard. That's a call that you have to make. Lawyers are our friends here at the court, and maybe you engage them just to do the deed of distribution or advise you on the inventory appraisement. I would always strongly recommend seeking legal counsel. And we talked about time periods. After a person dies, you have 30 days to deliver the will to the court. After you're appointed as the personal representative, you have 30 days to send out the information to heirs and devotees. And then 90 days after your appointment, you're to complete the inventory and appraisement. And you'll take a look at that. Questions, can you sell the house after the estate is closed? We can talk about that. Generally, you would list the house here. You can actually sell the house during the probate. We would look and see if you've got a powers clause. If you have a powers clause, then you can sell it without court order. But generally, any buyer, even if you have the right to sell the property, is going to want a court order. So, and after the estate is closed, the property is generally deeded, which we'll look at later, to the heirs or devotees, and they would all have to agree to probate, to sell the real estate. Well, let's take a look at the inventory and appraisement. You can see that we've got a recap there of the different schedules. The first thing that I'd have you notice is the non-probate and probate columns. You're only required to list the probate assets. For the example here, I list the optional, which is a non-probate, which many times can be more valuable than the probate. And then for each of these supporting schedules, we'll look back and there'll be a schedule like for real estate, you'll see here. This form, again, mirrors the Internal Revenue Service Form 706, which is the federal estate tax return. But most people don't have to worry about federal estate taxes. It's up over $10 million exemption index for inflation. So it's like 13 million per person, or between husband and wife, you're looking at 26 million. But the one thing that I would say, if you look at real estate, when you put the value down, that will be your new basis. And the one time the federal government is good to you is at death, or the federal tax code is good to you at death. They give you what's called a step up in basis, which means when you pass, the value of your property is not what you paid for it, but it's now what the value is at your date of death. And let me try to give you an example. If I bought a piece of property, say 30 years ago, for $10,000, and it's worth $100,000 today, if I sell it for the $100,000, I deduct my basis of $10,000, and I have a gain income of $90,000. Everybody follow that? If it went through my estate and I died today and my wife sold it tomorrow for the $100,000, she would get a step up, a free step up in basis to the fair market value at my date of death, which would be the 100. And so that's the big benefit. So the caveat here is to talk to your CPA, your accountant, your lawyer, and you may want to put real estate on the higher end when you put it down. Schedule A lists what we own individually or what we own with a spouse, which would be tenants in common. You'll see B, Schedule B, stocks and bonds. Generally, you get that right off from your brokerage statement. Cash accounts receivable, that's what you have in your individual account. Life insurance, generally a non-probate asset, but it can be a probate asset if you designate your estate as the beneficiary, or if who you named as beneficiary predeceased you, and by contract it goes to your estate. Schedule E is probably one area we see more and more assets. You don't have to list it again, it's optional, and that's when it's joint with right of survivorship. And I would caution you, anyone where they have a local child taking care of a parent, and the parent puts the child on the account, local child on account, as joint with right of survivorship. When the parent passes, that entire account by operation of law goes to that local child. If that's what mom or dad intended, then all is well. But if they wanted it to go according to the will and be split 5 ways among all the children, then you want to put the local child on the account, not as joint tenant with right of survivorship, but put them on there as the agent under the business durable power of attorney. And remember, the power of attorney is only good during life. So when the parent passes, it would be controlled by the will. Hopefully everybody follows that. Miscellaneous property, you just put a ballpark figure down there. Still looking for my Hank Aaron baseball cards, but it'll be worth a lot because I saw some baseball cards go for a lot. Transfers during life. The last one that I'll mention are encumbrances. Is you don't have to name all of your unsecured credit card debt. You just mention the debt that is tied to the property or tied, say, to a car or a boat. So it's a secured debt, not the unsecured. If you look back when we file this, you file an original. If you want to supplement it, you can do that also up there. So the inventory and appraisements due 90 days after your appointment. You'll get a bill, and if the bill is only on the probate assets, does not include all those other valuable non-probate assets. And you'll get a receipt from us. Earlier we talked about the creditor's notice. Again, this is a copy of an affidavit of publication. It runs once a week for 3 consecutive weeks. And if we look at that April 21st date with the star on the bottom, halfway down, bottom left, 8 months from that would be the creditor's notice expiring. Again, we get economies of purchase by handling it in-house. We make sure it's purchased, is published and put it in the newspaper. We will put a copy in the file and then also send you a copy as a personal representative. Let's talk about claims. Someone may file a claim against the estate. Again, if they do file a claim, you got 3 ways to handle it. You can pay the claim, say it's a valid claim. You may want to wait till the end of the the creditor's period to make sure you have enough assets to pay all the claims. You could say it's a valid claim, but say the amount's off, compromise it, or you could send a notice of disallowance. There's one up in Greenville County where the individual filed the claim on a white sheet of paper. Lawyers are known to argue everything. They argue that it should be on a pink sheet of paper, but Supreme Court said, no, you can file it on any color paper. So anytime we use different colors in here, you're fine with any color. And what we're looking for is that you've handled the claim, either canceled check or receipt, or that you send a notice of disallowance. If you send a notice of disallowance, then the creditor's got a choice to make. They need to petition for allowance, and they have 30 days to do that. And then we get an order related to the petition. And then when we get down to closing the estate, the real estate is, if you want to give up ownership to that, you file what's called a deed of distribution. And generally, you're going to wait the 8 months to make sure there's no creditors out there. Most estates, there are no creditors that can't be handled or paid. But if you've got an estate that you're not sure if it's liquid or not, you want to wait before you file that deed of distribution. Wait till the creditor's period is expired. Again, this is filed at the Register of Deeds office. It's considered practicing law, so we need you to consult an attorney to help you there, or you could do it yourself, but attorney probably is the best option. And then there are 3 ways to close the estate. One, if you're the sole heir, sole devotee, you can do a verified statement to close. 2, if there are other heirs and devotees, you can send them the standard closing documents, which is we'll be sending them the accounting, the proposal for distribution, the notice of right to demand a hearing, our application for settlement, basically saying, hey, we've done our job as personal representative. If you have any objection, then you have 30 days to come forward. I'll show you those forms in a minute. Another way is number 3, if the family is close and there's no issues, and many times the parent is the one receiving almost everything, they can unanimously agree just to file waivers of the statutory filing requirements. And then that way, they don't have to do the accounting and the other documents. So let's look at each of them. This is an example of a verified statement. Basically, you're the sole heir, sole devotee, and you're saying, I've done all my work, and so I'm doing this verified statement. There are no other heirs or devotees. The closing documents, typically we have an accounting where we detail what we did as during the estate. We put the detail on the back. We're just going to let everyone know what we did. And if they have a rejection, they'll have a form where they have to file something within 30 days. And then if we don't have something to be distributed, we'll do a proposal for distribution. Hopefully, if we give an asset, we have them sign a receipt. If we can get them also to sign a receipt and release, that's even better, because in the middle of that on page 44, you'll see in consideration of this distribution, the person discharges the PR to any claim against the estate. Can you use one attorney to deal with it? Yeah, a lot of times people do most of the probate themselves, and then on an a la carte basis, hire an attorney to help them with the deed of distribution. That's a good way to do that. And here's a waiver of the documents. If all the family will sign off on this, then we don't have to do those closing documents we talked about earlier. It depends on the family situation, but sometimes many estates are closed that way. And Uh-oh. And so these are the other. And this is an application to close. Right? And you're going to send them notice to right to demand a hearing. And at the end here, we're going to do a proof of delivery. If we notice on this one earlier, we had the 4 kids down there. We get ready to close the estate, we only have the 2. And those are the 2 that could, we're going to get distributions or devices. So. Good night. Here's the question, executor of an estate, executrix, I want to sell his home and car to minimize expenses before the end of probate. I said I need a petition probate to get approval to sell. How long does it take to get court approval? Should an attorney be for the petition court to sell a car and home? Yes, I definitely would consult an attorney to sell the home. Generally, what we're looking for is we would look in the will, if there is a will. If there's not a will, you can still petition to sell. Anyway, even if you have the power to sell in a will, the buyer generally wants a court order. If everyone is consenting to the sale, then we don't have to have notice in a hearing. If they'll waive the hearing and waive the notice requirements, we can sign it as quickly as you can get it into us. And generally, we're looking for an appraisal to make sure it's fair market value. If there are takers under the will or devisees or heirs, that they all sign off on the sale also. Buyers are very leery of property coming out of an estate. You may have the power to sell in your will without court approval, but many times the buyer and the title insurance company still wants the court to sign off on it, and we're gladly will do that.